All right. Well, welcome everybody to 2026. We are off to the races right quick. I thought this would be a good way to start the year talking about exactly how you prevent lawsuits. Okay. Now, let me tell you, I have been in human resources for 43 years. Okay. So I've been in house and made just about every type of mistake you could make out there. All right. And I went back to law school because everything was becoming so legalistic. And as of this year, I have been practicing employment law exclusively for 30 years. And let me tell you, the my clients who follow what I advise them to do, have never been sued. Never been sued. Now, I'll take you through this process, and it takes a lot of preparing, but I will tell you, it is very predictable when you're going to court. And I will tell you point blank, you end up in court when you dropped the ball. Something was not part of this system, and we want to make sure that everything is there. So that's what the agenda is for today. So hang on, and we'll get started here. Now, first and foremost, that's me. That's enough of me. All right. All of these lunch and learns that we do every month, and this one happens to be on the second or on the third Friday because I had to make a trip to Kentucky last week, but typically we are doing these on the second Friday every month on some topic relating to employment. All right. So these are always going to be posted by the next week, end of the week. If you go to my website where it says free resources, and I've underlined it there for you, free resources, click on Scott's Lunch and Learns. And if you click on the Lunch and Learns, they will all come up. They'll all come up. So all the past Lunch and Learns will come up. So if you've missed one in the past, knock yourself out. All right. And I am very, very thrilled to announce that as of this month, my book, Tolerance and Diversity for White Guys and Other Human Beings. People seem to forget about the other human beings part. That is on audiobook. So yeah, you don't even have to read. And now that was the original title, Tolerance and Diversity for White Guys and Other Human Beings, which should be everybody. Thanks, Jen. All right, like the little, yeah, I got the emojis going here already. That's great. Then that got me death threats. It was amazing to me because white guys are the problem. White guys or whatever. And that led to me being canceled. I complained, white guys are not all racist. White people are not all guilty. So guess what? I put it out, the same book, under another title, Living the 5 Skills of Tolerance. It's the exact same book. So for all of you PC people out there, Living the 5 Skills of Tolerance might be your cup of tea. But if you want to learn about what has gone wrong with diversity, and it's really interesting, I wrote this book 4 or 5 years ago. It absolutely predicts everything that's happening today in DEI. I told you 3 or 4 years ago this was going to happen, and now it's here. And this talks about how we correct that. So I would encourage you to take a look at that. It is on audio, and bon appetit. And I also want to remind you, it was a hot year. 2025 employment law update. Oh, major, major changes to the EEOC, to diversity, to the standard that we use to determine what is discrimination from the United States Supreme Court. All right. Tax on tips, a change in the standard in which we evaluate exempt and non-exempt status. All of these are all new. And so time's running out. The first session, which is going to be all day on Zoom, Friday, January 23rd, a week from today. And then another one on Wednesday. Sometimes Wednesday works good for people. Sometimes Friday works good for people. So you can go to my website and sign up for that if you haven't already. A lot of you already have. And I'm finishing up the materials here, and it just never stops. It's actually a pretty fast race to see what all is going to make it into the program. All right. And if you are interested in getting things put together for yourself, train your employees, update your policies, your contracts, legal consulting for free. Yeah, I said free. Well, it's not exactly free. It's paid, reimbursed by the state of Ohio. And that is under a new program they started in July 1st of 2025. And a lot of you have already taken advantage of this, and that is great. And you're going to see this is a big part of getting ready for 2026. Now, let's get off to the races here. Why are we here? So you don't do something stupid. Okay, now let's just do one of our first little polls here because I like my polls and the reactions and everything. How many people in 2026 don't want to do something stupid? Give me my thumbs up there. Yep. When you do something stupid, we call it stupid. When I do it, it's called malpractice. So, I'll tell you, I'm not ready to practice law every year unless I do legal update. I'll tell you, every year it changes the way I practice law and the way that I set up HR departments. So don't do this. Now, let's get right down. I'm going to give you a big overview of my process. And every piece of this pie has to be in there. Okay, so you got a problem child employee. So how do we start? We start with coaching. And that is what I like to use, my EPR system, empathic listening, parroting, and rewards. So you got supervisors who come in and they're afraid of conflict. Oh, I'm a nice person. I don't like conflict. I can't sit down with employees and do that. Wonderful. You've got one response to that supervisor. What other job would you like to do here? Your job is to manage employees. Your job is to address and resolve conflict. And you've got to understand, if all employees came into work on time, they all took their assignments, there was never any drama between them, I wouldn't need you. There's a lot of things you got to do as a supervisor. That's number one. Number one, you've got to address and resolve conflict. So, properly. So we use our empathic listening, our parroting, and our rewards, and we find out what's happening with the employee, and we put together a plan. Okay, well, the employee doesn't do it. So you got to sit down again and coach them and say something like, hey, wait a minute, we talked about this. What happened? I thought everything was going good. And you find out what's going on. You reinforce the plan. Doesn't work. So you do 2, maybe 3 coachings. And now it's time for the written warning. Supervisors absolutely positively have to work with human resources or legal counsel or somebody to put that written warning together because that is going to be Exhibit A. All right. And I mean Exhibit A with civil rights. Now, you put together the written warning, and I got a session in the last Lunch and Learns as to how a written warning should be written. And I will tell you, 9 out of every 10 written warnings that I've seen in my career, I wouldn't even line my shoes with them. They're terrible. And why are they terrible? Because they're so vague. They are full of conclusions. Like, Bob isn't doing his job, or he has a bad attitude and he must improve. Okay, where's the observables? Where's the facts? I want that loaded. Because I should be able to hand your written warning to somebody off the street who's never seen you, doesn't know anything about your company, and they should read through that and they should look up and they go, oh my God, you got to fire this guy. Okay, so you deliver the written warning. Maybe there's another written warning in there. Okay. Then the employee gets fired or quits and leaves and is going to sue you. You get a demand letter from an attorney saying that you're horrible, terrible people and you're all going to burn in hell and you owe my client $1 bazillion million. Okay, Real nice. All right. Now, here's a good question for a room full of very experienced people. How many people you've ever had a lawyer, your lawyer, tell you, oh, we're not going to give anything to them now. They will get all of that in discovery. Has anybody ever heard that? I'll give you my emoji on that one. You can chat me up or open your phone or your mic. Yep. Darlene. Yep. Lots of uh-ohs. Uh-ohs. Yeah. Do you know what that means? It means you are getting screwed. What's that mean? Billable hours. Why in God's name would your attorney turn all of that stuff over to them now when they can bill you $500, $600, $700, $800 an hour to release it in discovery? And how do I know that's what they do? Who do you think did it to you? Oh, let me tell you right now, if you work in a big law firm or most law firms, billable hours, billable hours, billable hours. Oh, no, 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 no. Here's our process. We're going to take all this work you've done, all the coachings, all of the warnings. We're going to respond to that attorney. I'm going to write a letter saying this is the truth. This is everything that we put together for your employee. Your employee is not being honest with you. We see this as bad faith. Now, what's bad faith mean? It means it's a frivolous lawsuit, and that attorney will know you better make sure that you got your ducks in a row because I've loaded both barrels here. I've got your employee dead to rights. And if you pursue this, I'm going to claim it's in bad faith. What does that mean? It means we can sue the employee and the lawyer for your attorney's fees. I'll tell you right now, this is the only way to go. Now, let me make it clear here. There's nothing you can do about someone going to civil rights. It's free. It's okay. But boy, going to court, you get into big, big bucks. Okay, so you see the overall process. It all counts that these T's are crossed and I's are dotted. Okay, so what's the first thing we got to do? You've got to update your policies. I have reviewed a couple of dozen handbooks with the program getting reimbursed by the state and everything. I've done several of these in the last year. I'll tell you, I haven't seen one yet that I would use. Not one. Okay? Because a lot of times they're written to tell employees what their rights are. No. You write a policy to reserve the rights for yourself. And I'm going to go through some of these in here today. I want a policy manual that paves the road, that has everything in there that I'm going to need if you have a problem child. Now, understand, you probably don't need much of a policy manual for 90% of your employees. But let me ask you, if you gave a $1,000 bonus to all your employees, wouldn't 5 to 10% complain they had to drive in to get it? Mm-hmm. What do you think? I mean, they would boo a home run because now there's nobody on base. No, no, no. These are your problem children. And God apportions trolls to everybody. A troll is my term for a problem person. Okay, yep, Diane's giving me a big yes here. Absolutely. These rights have to be in your policy manual. I may say that again. They've got to be in there. I'll tell you, it is amazing to me how many of these handbooks I've seen that don't have these protections in there for you and actually refer the employees to specific laws that protect them and how to go about complaining if they're upset. Like, you can contact the EEOC. No. Oh, how many people, has anybody ever gone to read that 6-in-1 poster you got to hang up? Has anybody actually ever read that? Oh, it'll give you heart palpitations. Absolutely. You are not there to tell them what their rights are. You're there to protect the company. Now, policies. Now, let me just draw this distinction here because you should also all be using contracts. Now, we're not going to get too much into contracts. I got another Lunch and Learn that talks about those. But policies tell the employee what rights you've reserved during the employment relationship. Okay, during the employment relationship. So when the employee leaves, your policies all die. So you can't enforce a dress code against somebody who doesn't work for you anymore. Same thing with things like confidentiality. Okay, confidentiality. It's like, well, we got a confidential information or a confidential policy, and the person leaves and starts giving away all kinds of confidential information. Okay, somebody screwed up. You needed a contract for that. Okay, so yeah, that reserves your rights after the employment relationship ends. And I'll tell you right now, I've also never had anybody breach my contracts, ever. Because in every contract, I put in there that if the employee breaches this contract or even threatens to breach this contract, that's anticipatory breach. You owe us all of our attorney's fees. I'll tell you right now, that scares the fur off of anybody. And this applies to getting your equipment back. I'll tell you, if you're checking out expensive equipment like cell phones or laptops or Macs or something to people, man, I want them to sign that they are responsible for that, and they will return it to you in used but good condition when they're done. So anyway, let's focus on policies. What are just some of the things that absolutely have to be in your policy? Well, first and foremost, I want this at the beginning of every handbook. I do not want an attorney or anyone to argue, well, we think this policy should have been interpreted this way. No. When interpreting the enforcement of these policies and their various applications to the workplace, management will use its best judgment in order to interpret and enforce these various rules in order to run the organization as it subjectively deems best. In other words, we're not going to get into a spitting battle as to how the employee thought a policy should have been administered. It's our choice. Now, we need to make sure that we are enforcing our policies equitably, not equally, but equitably. What's that mean? It means, yes, you're allowed to treat different classifications of employees differently. For instance, your vacation policies. Don't you give more vacation time to exempt employees than you do non-exempt? Yeah, that's very common. That's not illegal. Yeah, there you go, Senta. It's not illegal because you're treating entire classes of people with equity. You're not treating exempt and non-exempt people equally. You're treating them within their groups. And that's what the law says. You got to treat substantially similar people the same. Okay, what else we got? You do not, if you're staying up on your handbook, you could be updating your handbook once a year. Are you actually going to go and have everybody re-sign the handbook every single time that you update it? That's insane. And I'll tell you, sometimes we put new policies in place and we don't get the signatures. No. We want the policies current and we want them in force. So this needs to go into your handbook as well. It is each employee's responsibility to remain informed regarding the company's most current policies. Policy changes will be posted, and then you put where you're going to post them on your intranet or wherever, as soon as practical after these changes are adopted by management. Employees acknowledge. Now that's a big one right there. Employees acknowledge, they understand. Never put agree. This is not a contract. Agree means agreement. Agreement means contract. I see a lot of those too. Employees acknowledge. I don't need their agreement. I just need them to understand this is how we're running things here. Employees acknowledge that they are to check blank every so often to see if any updates have been posted. Employees may also be notified of various changes by way of email, posting in the lunchroom. Okay? So guess what? You're not going to run into a problem where, well, we posted this policy change and no, we didn't have the employee sign that they noticed it. No. If you don't have this in your handbook and you make a change to your policy manual and you don't have that employee's signature that they were aware of it, you can't rely on it. This clause takes care of that. Now, can you tell right away that I was an in-house HR director for 10 to 13 years? Yes, this is one of those things that I have screwed up. I'll tell you, how many people in here have ever screwed something up really good? Really good. I mean, really muffed it. Yeah, boy, I'll bet you never do that again, huh? Oh, yeah, and I got a bunch of them. Okay. Now, give you an example. For you Ohio employers, okay. Ohio is very different, just to pick on Ohio for a minute. Most states, when you pay vacation time, and it's, vacation time is given to them, that is a cash advance. That is a compensation advance. So guess what? You got to pay that out when they leave. Mm-hmm. Not in Ohio. If you don't want to pay out vacation time, you don't have to.
Wow.
But you got to put it in writing. Oh. It's got to be in writing, putting that employee on notice. Now, this is a very common type of thing that I put in here. Usually you want to have a proper resignation. And if they don't give a resignation, you can withhold their vacation time. Now, that's not legal in a lot of other states, but it is here. I got some nice comments here. Jim, that's why I had Scott write my employee handbook. Yeah, that we go through like we're going through a dog looking for fleas. Now, what if people negotiate their PTO when considering the job before signing the offer letter? If someone's negotiating something, you decide. Now, first of all, I never give them vacation time. I just give them additional personal days. And the reason being is I don't have to get into this battle over whether it's paid out or not. You can specify that those additional, personal days are not paid. If you want them to be paid, then fine if they leave. But it's up to you, Courtney. See, that's the thing, Courtney, that's a great point. You personalize your handbook to fit you. Fit you. Outside employment. Okay, this is a big hot topic. Now, first of all, in a lot of states, you want to know if somebody is working outside employment. The reason being is, let's say somebody is moonlighting with another job. Okay. And they get hurt on that job and they miss work and file a workers' comp claim. That injury from that other job, they will get money from that job from workers' comp. You will also have to maybe pay workers' comp, depending on what state you're in. If you're in Ohio, you definitely will. Now think about this. You put all kinds of safe processes in place. You don't know what these other employers are doing. And lo and behold, your employee gets hurt at one of these other places. That's going to affect your workers' comp. You will be paying for that. Okay. Oh, thank you, Phoenix. Yeah, I think that is interesting. Well, that's why we're here today, isn't it? There's all these little things out there. Plus, if you've got somebody out on FMLA, and I had this come up a few times, I've got somebody that is a guard, just walks around at a nursing home. Just security, just walking around. Well, they might not be able to do the job for you, but they're within their limitations for ADA and FMLA. So guess what? It's perfectly legal for them to work off the job or moonlight while they're off on leave. What are your other employees going to think about that when they're having to cover for everybody? I think they're going to be upset. It is perfectly legal to forbid people to work other jobs while they're on any type of personal leave, family, or medical, if you want it. But you see, writing your policy manual is exactly like a buffet. You've got all these rights up at the buffet. If you don't go get them, you don't have them. Oh, and by the way, putting a policy in after the employee has had this incident, too late. Insubordination. Oh, let me tell you, this one is a big one, and I'm talking in particular to the private employers out there, not public sector right now, but private, and that includes nonprofits, private. Insubordination. Under the National Labor Relations Act, which governs unionization in this country, and even if you are not union, your employees still have a right to unionize. Okay, what's that mean? They have a right to go out and complain about you. And I'll go one more. When we got Legal Update next week and the week after that. I'll tell you right now, in a lot of instances, these employees can cuss you out, call you things George Carlin wouldn't even say. Now that'll date me. But I will tell you right now, I have seen more illegal handbooks coming from SHRM. I mean, I saw somebody pull a policy off of SHRM's website and for one of these types of things, and I was looking it over and I said, it's illegal. The policy is illegal. Or they got it from a big HR consulting firm. Okay, still illegal. You cannot forbid employees to badmouth the company. Oh, I love this, Addie. Addie, SHRM has never broken a law ever. Much sarcasm in there. Okay. Oh my God. Okay. Well, I'll be doing more podcasts on SHRM. I just personally refer to them as the evil empire. Oh my God, it's like Darth Vader is running things over there. Anyway, that's enough of him. Oh my God. And so guess what? This is illegal insubordination policy. Now, employees can go out and badmouth you and say anything, but the National Labor Relations Board said employees are not allowed to go out and make statements that are defamatory, vulgar, obscene, threatening, maliciously dishonest. You can be dishonest, but you can't be maliciously dishonest, which I see the humor in. Unlawful or illegally discriminatory or harassing towards the company, its employees, or competitors. Beverly is asking, I've seen language about not being able to use defamatory language in severance agreement. Is that illegal as well? No, Beverly, I'm afraid you got some bad advice there. You're allowed to keep them from defaming you. That's a legal term. Okay, so no, Beverly, I'm glad you're on here today because I'll tell you right now, after 43 years in HR and 30 years of practicing law, I think I'm just now getting really good at this. I just turned 65 last year, and I'm just really now starting to figure all this stuff out. And Beverly, it just breaks my heart when I hear somebody that gets that type of advice. I had a lawyer once say, well, this employee can't go out there and say bad things about you. We've got a say give away your confidential information. We've got a confidentiality policy. And I looked at this guy who's an employment attorney, and I said, really? Are you really going to try to make new law and enforce a policy against a former employee? No. See those words right there? You will see those throughout the policy manual that I put in there. Okay. And I will tell you right now, insubordination, professional conduct, all of those types of policies, without that type of language, it's illegal. It's illegal. So I can tell you, I don't know any HR person who wants to put together an illegal policy manual. So everybody with me? Okay, here we go. Personal conduct. What they do off the job affects you. So guess what? Employees are expected at all times to use their best efforts in performing their duties and treat clients and customers, competitors and vendors with respect. Now right there, it is legal to say clients, customers, competitors, and vendors. You got to treat them with respect. When I write personal conduct, that's really insubordination. I can't say that they have to treat management and their coworkers with respect. They don't have to treat the company with respect. They can be very disrespectful. They just cannot do that. So you kind of see, that is legal. That is legal. On and off the job. Because every so often you get employees who go out there and go off on your customers or something on social media. No. And so I tell you, no, what you do, you always work for the company. So insubordination, personal conduct, on and off the job counts. Social networking. You gotta have a good social networking policy because everything is social networking. Employees are not to make defamatory, vulgar, obscene, threatening, malicious, there you go, you're getting used to that. Comments about the company's employees, clients, So I just wrap it all in there together. Now, think about it. Most employees think going out there and bad-mouthing somebody, defamatory, vulgar, obscene, but that they can't do that. That's great. I don't like people going out there saying nasty things anyway, and it's almost always going to be a troll. Someone who's just got an axe to grind. So yeah, social networking. I want that same language in there. And again, there's your personal conduct again. Again, you see right here, we have personal conduct for the company or the clients. Now you see how this is different for the employees relating to coworkers and supervisors. See how it's different? That's the difference between legal and illegal. Paycheck review. This is a big deal. This is your safe harbor for Fair Labor Standards Act. If you accidentally make a mistake on, which we all make mistakes in payroll, and let's say you make a mistake that invalidates an exempt employee's salary status, okay, like you dock them for a partial day absence or you do something, okay, you can correct it and you're allowed a few mistakes. This is a safe harbor paragraph. This absolutely positively needs to be in your policy manuals. Employees are to review their paychecks in detail when they receive them. If employees discover errors in their paychecks, they got to contact, whoever immediately. You see, this puts the onus back on the employee to let you know ASAP, as opposed to hitting you with this weeks or months later and then going to the Fair Labor or going to Wage and Hour. And this is just a good policy anyway. And that's the same thing. We might make a mistake. These two go together. We might make a mistake. If you feel there's been a mistake, you got to contact us. Is everybody with me? These two go together. This is a big issue. I ran into this years ago where I had employees that would just purposely say that they were working off the clock. Okay, they said, well, my manager told me that I had to work off the clock because we didn't pay the overtime. So this was in a Wage and Hour audit. The employees called Wage and Hour showed up. And I said, no, employees are not supposed to work off the clock. They need to have it approved, and we'll approve it. But no supervisor is out there telling somebody to work off the clock. You know what the Wage and Hour investigator said? Well, show me a policy on that. I didn't have one. Well, I got one now. So guess what? If anyone tells you to work off the clock, you can get fired. No one's got the authority to tell you to work off the clock. Working off the clock is a disciplinary offense, as is ordering an employee to work off the clock. Any employee who is ordered to work off the clock must contact blank as soon as possible. I've never had that problem since. You see, this policy manual is to protect you. And, oh my God, bullying and harassment is through the roof today. And I mean literally through the roof, okay? And now guess what? Your policy has to encompass both. Has to encompass both. And I mean a thorough policy. A policy that states what hostile environment is and what it isn't. A policy that says what it means to be offensive. Okay, and let me just tell you, what does it mean to be offensive? This is from the United States Supreme Court in 1993. Okay, so long time ago. 33 years ago, right? What is offensive? Not what's harassment, but what is offensive? If that was on the front page of USA Today, would most people think it's offensive? That's the test, and that should be in your training. Now think about it. I get people upset because someone used the wrong pronoun by mistake, or that someone referred to someone as black as opposed to African American, or on and on and on, or somebody looked at me mean. Okay. One of my discussions, as I'm using my EPR conflict resolution system, I'll ask them, if that was on the front page of USA Today, what would most people think? Would they find that terribly offensive? And the person usually says, well, I don't care. I know I find it offensive. Well, that's okay, but that's not the test. You see, that's the test between what's really offensive and what is hypersensitivity. All right, how many people, let's do another poll here. How many people, you got hypersensitive people at the ranch that if you look at them sideways, they're upset? Yeah, the United States Supreme Court would say, live with it. You went out in the society today. You're gonna see things that are offensive, okay? Now, just as a little tip here, never tell a hypersensitive person that they're hypersensitive. It won't go well. You know, it's a lot like I've discovered stupid people don't like being, have it pointed out that they're stupid. They don't like that. So we don't say hypersensitivity. What do we say? Well, that's one of your pet peeves. Now, of course, we're going to make sure that we call you what you want to be referred to in the future or something like this. But I'll tell you, all that stuff's got to be in there. And I even have something in there saying that we can't fix what we don't know about. Your job is to let us know. And we got to know what the problems are. So there's a lot of stuff that needs to be in your bullying and harassment policy. And I'll tell you right now, if you've got an FMLA leave policy, if you're covered by the FMLA law, and your policy is any less than 5, 6, 7 pages, it's not enough. You're missing stuff. It's not complete. It's not possible. Let me say that again. It's not possible to write an FMLA policy that conforms to what you want people to do and have it complete in less than 5, 6, 7 pages. All right. Now, why is that important? Because when it comes time for FMLA leave, all of their rights and responsibilities are already in your policy. They're already in there, which includes your personal call-off procedures. So when it comes FMLA time, somebody's going to take a leave, somebody's, taking some time off, somebody's doing something. You already put them on notice as to what their responsibilities are, like working off the job, like all those things. You see, those types of pieces of the FMLA policy, they're not in the federal forms. So guess what? When you give somebody FMLA leave, you have to give them a listing of all of their responsibilities. Well, what do you think I'm putting in the handbook? It's already there. So the chances you're going to step in an FMLA gopher hole are greatly reduced. Okay. And of course, in today's world, you certainly want something in there. Employees are allowed to say terrible, horrible things about you. Now think about this. I'll see these all the time, that company equipment is to be used exclusively for the company's benefit. That's illegal. That's illegal. And how's it becoming illegal? Do you ever go out to eBay and see how something's going? Do you ever go out to Facebook? Do you ever go out to LinkedIn at work? See, right away, you can't enforce that policy. Okay. And the National Labor Relations Board has ruled for all of you private sector employers out there, employees have a right to say the most horrible, terrible things about you in their emails. Now, I got a good one here from Phoenix. I've seen policies say de minimis use. That's okay. That's okay. But I've also seen, things like, well, you're not allowed to go out there and disparage management. You're not allowed to go out there and say bad things. No. Or I've seen somebody get written warnings for sending an email saying that Bob, my supervisor, is an effing jackass. Okay. Oh my God, that's insubordination. Well, you better stop and think. Okay. Employees are prohibited from using any of the company system to create or send any communications that are, and there's our weasel words again. Okay. I'll tell you, company equipment, texting, messaging. And let me tell you right now, the world of discovery in court has all become digital. It's really funny. People, I would never say anything like that. I'll just text it. Oh, no. Now it's permanent. Oh my God. Violence. Okay, now get this definition from OSHA. Any type of physical, verbal, or nonverbal threat occurring inside or outside the work setting. I want that in your policy manual. Yelling at someone where the reasonable person would feel threatened is workplace violence. Kicking a trash can across the room is workplace violence. Stalking somebody outside of work is workplace violence. And I got news for you. You're responsible for that. We call this negligent retention. Okay? So I'll tell you right now, you train your people and you'll get questions like, so if I go outside and I start screaming and yelling at somebody, somebody's going to talk to me? Yeah. Yeah, absolutely. That's verbal abuse. And here's the logic. It takes a while to get from, for most normal people, to get from calm to upset, to get to from upset to angry, to get to enraged. That takes a little bit. It takes a worm hair to go from enraged to physical assault. Okay? So that is right from OSHA. Phoenix is putting in here, as a neutral, I've heard an employee say that they could say whatever they wanted to employees in management once they're off the clock. Oh, that's great, because that's not true. That's not true. Well, have you reserved the right that you always represent us? Okay? And think about it. A lot of people, put it this way, if you get somebody that goes out and gets in a bar fight, starts a bar fight, well, that's off the job. Is that any of your business? Yeah. That person has shown a propensity for violence, and you're looking at a negligent retention suit if that person does anything in the future. You kind of see how we're paving this road and reserving all kinds of rights for whatever comes up. And I can tell you right now, with weapons and drugs, oh my God, particularly if you're an Ohio employer where, oh my God, alcohol, drug abuse is through the roof. And understand, Ohio, Kentucky, Pennsylvania, and West Virginia were targeted by the Sackett family for OxyContin. Well, that's why fentanyl is so popular right now. So I can tell you right now, whether it's weapons or stolen material, stolen equipment, you reserve the right to search at any time. At any time. And guess what? If they refuse to let you search the car, well, first of all, they're fired. Second, call the police, because what's in the car? I can tell you, you threaten to call the police and they got some heroin or they got your copier in the trunk, they're going to get real cooperative real quick. Oh, I'm getting here. We have multiple high-level leaders who resort to literally yelling when they don't get their way. That might be a good thing to speak up about there, Courtney, because employees are allowed to do whatever they want to do. And quite frankly, if I was a plaintiff's attorney taking that case, oh, that's workplace violence. If you're screaming and yelling at an employee like some wild person, you do understand that that is already assault. That's already assault. That's violence right there. Battery is when you actually hit them. So, oh yeah, Jim, I work at a court. We would see our employee in court for a bar fight. Yes, you good man, Jim. Absolutely. Oh, and employer notification. I want to know if you get arrested. Not that you're convicted. I want to know if you're arrested. And I want to know within 24 hours because you've got negligent retention issues. Public sector, private sector alike. I want to know about it, and I want to know about it now. That has to be in your handbook. And when you do an investigation, I want this in there. They cannot give misleading information, anything dishonest. They can't withhold anything. And if they do, that's a disciplinary offense. Well, I don't want to participate. Then we don't want to pay you anymore. Honestly, you're investigating something because there's a serious issue. I expect you to be honest. Imagine that. What a novel concept. We actually want you to be honest. And here's the big one. Here's the big one. I saved this for last. All employees are required to sign your written warning forms. I am never going to let you out of a room and as an employee If you refuse to sign my written warning, my performance appraisal, no, immediately terminable offense. Because I've seen judges refuse to put warnings into evidence because they weren't signed by the employee. Now, traditionally, what have we been told to do? Well, you get a witness who then witnesses that the employee won't sign, you both sign it. No, that's a load of crap. That is someone who doesn't go to hearings or to court very much. All right, let me tell you, no, because the employee can sit there and say, well, they're both lying. They're both liars. And quite frankly, if they don't sign your warning forms, they just gave you a gift. That means they're too much of a jackass to keep. And think about it, you coached them, maybe coached them a third time, now the written warning. Well, I'm not going to sign that, but then here's this section of the handbook. If you don't sign this, you are terminated immediately. Oh, and by the way, part of my system is if there is ever a termination meeting, if there is ever a written warning, I bring them in and I say, I'm going to document this. We're going to have this session fully documented. I'm recording this entire meeting. And they'll say, well, I don't want to record it. Okay. You're not running things. That's why you're here now. You think you run things. No. And I'll tell you, why do I record it? Well, number one is because they're secretly recording you. All right. In like 46 states, it's perfectly legal to secretly record somebody as long as you're a party to it. And for those other 4 or 5 states, guess what? You're still allowed to do it because the National Labor Relations Board says that's okay. Okay. Now, having said that, they're recording you. And second, they forget it's running. I get called, all kinds of names. They call me something horrible. I'd give them $100 to call me that again. And they'll probably say something about your mother. Wonderful. Okay, now what am I going to do with that recording? I'm going to send that to their lawyer. This is what we're dealing with. I'll tell you, if you record a session and they do that, oh, you've got no trouble. You got no trouble. You see the system? Now, here's another thing you got to think about. You absolutely have to train your managers. Your managers, you'll see in Legal Update next week and the week after that, a lot of cases come about because managers plain don't know what they're doing. They don't know what they're doing and they don't work with HR. Well, first and foremost, let's get their attention. Let's make sure they know that it's their butt on the line. In states like Ohio, we have something called the Employment Law Uniformity Act. What's that mean? It means that if you are involved in any type of retaliation against somebody, or anyone, that means a supervisor, coworker, who aids and abets. What's aiding and abetting? You helped commit the illegal harassment or discrimination, or you didn't do anything to stop it. So guess what, supervisors? You're not just looking out for the company. Do you like your house? Do you want to keep your retirement? Because I can tell you right now, if you put it this way, if you are going to discriminate or harass somebody, you better do it in a state other than Ohio. And a lot of other states have these laws too. So I think it's kind of treason. They're there to look out for the company, but you know, this does tend to motivate them. So guess what? You better be doing what we're telling you to do, and you better be working with HR. Make sure they know what discrimination is. Okay. It's not discrimination to treat one group of people differently because of their vacation, like supervisors and factory workers. What is covered today? Oh my God, look at this. Race, color, religion, national origin, sex, and yes, sex includes sexual orientation and gender identity. No, you can't go out and harass the transgenders. It's illegal. Oh, and remember your personal liability there, pal? Age, pregnancy, Americans with Disabilities, ADA. Oh my God, we did a whole session on the ADA a few months ago. That's the big anaconda. Pretty much because everybody's disabled. And guess what? It's not just time off under the ADA. it's changing their job all around. And what do I typically get? I get some supervisor saying, well, I just know they're sticking it to us on the FMLA. I just know they're sticking it to us with the ADA. And of course, the latest, the Pregnant Workers Fairness Act. Boy, you better watch out for that one. Though the EEOC is on fire over that one, and that's a new law, and employers are dropping like flies. So, in other words, why don't you treat your employees with equity? Treat them based on their performance. What else do supervisors have to know? They got to know what documentation is. Now, let me just give it to you to the skinny. What is documentation? If it isn't written down and delivered to the employee, never happened. Never happened. Well, I told the employee this. Really? Did you put that in an email to them later to tell them that this meeting went well? That's how I like to document coachings or verbal warnings. Send a follow-up email. Hey, I thought our session went well. Here's what we talked about. It's time-stamped. It's great. Or is it in the written warning? Did you go and list all the verbals in the written? Well, she's making these mistakes. Well, did you tell her about the mistake? Well, no, but here it is, as big as God. She made these mistakes. No, she didn't. She did it right. No, she didn't. Yeah, she did. Because you didn't say anything to her. It doesn't count. Oh, and by the way, is your house paid off yet? Because the employee is really going to want to take your house. I don't know too many individuals who can afford the $50, $60, $100,000 in attorney's fees. Oh, I tell you right now, this should be imprinted on your liver. If it isn't written down and delivered to the employee, it never happened. And you will never make an employment attorney go away without that. Okay, coaching. We knew this was coming. Okay, we talked about warnings. Number one, if you cannot address and resolve conflict, you cannot be in management. Period. That's why you're there. And that's the EPR system. Your managers absolutely, positively have to be trained in how to address and resolve conflict. And I recommend empathic listening, parroting, and rewards. It's so simple. Anybody can do it. Well, how do you get started? You sit down and say, Bob, you're making all these mistakes. What's happening? And you shut up. It's not your job to do the talking. It's the employee's job. I want to hear what they have to say. And then we go through parroting it back and everything. The biggest problem is fight or flight. See the little devil angel there? See the little devil troll and little angel troll? That's fight or flight. Some people, like your managers, go right to attack mode. They're like Simon Cowell, right? They go right to attack. I tell people like it is. Okay. Now remember that recording? 33 to 50% of all employees in this country secretly record their employers every day. Did you get that? 33% to half of all the employees in this country secretly record their employers every day. So if you got Simon Cowell, or we had some mentionings of some upper leaders that are screaming and yelling. I'll tell you, 4 or 5 months ago, I had an employee cough up a recording where the president of the company is using every word George Carlin says you can. And oh my God. And I just looked at him, I said, you're going to have to settle this. But we didn't do anything wrong. Oh no, but I can tell you right now, a jury's going to hate you, civil rights going to hate you. I mean, yeah, you can pay $150,000 to win, but you're not going to make this go away. And you see, that's where the battle is. We're not here to win lawsuits, because if you pay the fees to the attorneys, you've already lost. You're here to make them go away. So you got the Simon Cowells of the world. Most of your managers, though, they're nice people, like Aunt Bee from the old Andy Griffith Show. I'm a nice person. I'd never want to upset anybody. Oh my God. No, you're an evil harpy. You're an evil person. Just, yeah. I mean, if you watch the show, which is on TV Land 24 hours a day or something like that, whenever there's a conflict, you got old Aunt B sitting at the kitchen table with her old bitty friend Clara talking about everybody behind her back. 80 to 90% of everybody you know is a passive aggressive. And understand, that's naturally fight or flight. That's how we humans are wired. No. If you're going to be in management, you got to be an honest, respectful communicator, which means I am not going to pull anybody who's ever spent any time with me is not at all confused on how I stand on things. You are going to get truth and you're going to get it right off the top of the deck, but I'm going to be respectful for you. I'm not going to tell somebody that they're stupid right to their face. I'll probably think it, but I won't tell them that, okay? I'll use my EPR skills. That's what I'm going to do. Your supervisors have to do that. And you've got to make sure your supervisors understand you are not going to protect your own people. No, that's what got Penn State in trouble with Jerry Sandusky. Oh, we're going to protect Jerry. And Penn State covered up and paid off a child molestation lawsuit in 1971. 1971, they're going to protect Jerry. And for the next 40 years, he molested children on behalf of Penn State. He used his position as defensive coordinator. Now think about it. They should have corrected their own. We are not here to protect our own. We're here to correct our own. We're here to help you. When you sit down to coach somebody, you're there to help them, not to crucify them, because if they keep doing what they're doing now, they're going to be in trouble. That's for substance abuse. That's for workplace violence. That's for mistakes in your work. It's everything. Being Aunt B and protecting your own will doom that person. And one last thing to think about, your managers absolutely, positively have to recognize when someone is asking for help under the ADA and FMLA. This is a source of hundreds of lawsuits. Now, let me make this very clear. They need trained in this. An employee only has to ask for a change or adjustment due to a medical condition. That's it. They don't have to say ADA. They don't even have to spell ADA. So what would count? Well, I'm in a wheelchair, or I have trouble walking. Yeah, I have trouble walking. I'm not in a wheelchair, but I have trouble walking. And you got the fire drill coming up. Can I take the elevator? No. Okay, because you'll die. But has the person asked for some sort of chain or adjustment? Yeah. Due to a health condition? Yeah, that counts. Oh, my hands are really sore. I don't think I can do 100 widgets today. Okay. Did the employee tell you that something's wrong for a medical condition? Yeah. Did they ask for a change? Yeah. That is ADA. Or if they say, I got to go home because my hands are hurting so bad. Okay. They asking for a change? They asking for a medical condition basis? Yeah. Guess what? FMLA, ADA. And what's their job? To call you. Make sense? That's a lot of stuff. And I will tell you, it's a lot of pre-work. But the bottom line, if you cannot address and resolve conflict, you can't be in management. And we need these safeguards in place. And for those of you who are Ohio public, Ohio private, Ohio nonprofit, or whatever, yeah, we can get reimbursed by the state. And these are your codes for today. I meant to put those earlier, but there they are now. So that's your HR certification code, 730138. 730138. Okay, well, I wasn't able to see all of the chat going on over here, but hey, if any of you want to give me a call, give me a buzz. It's always great to talk to you. And don't forget, next week and the week after that, I'll tell you, it's time to sign up for Legal Update. It's coming and it's going to be gone here pretty soon. And it will recap all the big stuff from the last year. And if you want to talk about any of this other stuff, give me a buzz. All right. Well, hey, y'all take care, and we will see you next month.